Good morning, and thank you for joining us for the Debevoise and Plimpton and Castle Placement Global Seminar on FinTech Disruption and Incorporation, Innovation, Capital Raising, and Bank Regulatory Framework. I'm Greg Lyons, partner at Debevoise and Plimpton, and I'm joined by my colleague Neha Prakash and by Richard Luftig and Ken Margolis from Castle Placement. We very much appreciate their attending. Just a few housekeeping items before we begin. If you'd like to receive CLE credit, please download the CLE form listed under the resource section of the console. At the end of the program, we'll announce a 5-digit verification code. Please be sure to include that number when filling out your form, and we'll be happy to send you the relevant credit. If you have any questions during the live session, please enter your question in the Submit a Question box on the console. We have a lot of content here, so we will be responding to the questions after the presentation, but we do plan on responding to them. You can also use this box if you're experiencing any technical difficulties, and you'll be contacted by a technician. So we have a lot to cover, and we very much appreciate Castle Placement being here, so let's get started. I'll turn it over to Ken Margolis.
Thanks, Greg. Today I'm going to give a quick review of the FinTech market, and then Richard is going to speak about the state of capital raising. In 2017, over $24 billion of private capital was invested in U.S. FinTech, including $16 billion in private equity, $7 billion in venture, and about $1 billion in ICOs. In addition, there were approximately 172 U.S. M&A transactions involving over $19 billion in 2017. In the first quarter of 2018, we saw over $27 billion due primarily to Blackstone's acquisition of Thomson Reuters' financial and risk business for $17 billion. In the first quarter of 2018, we saw a record of $2.5 billion in venture rounds. Drilling down, average round sizes and valuations have gone up dramatically. Not surprisingly, late-stage deals account for approximately 76% of the total capital raised last quarter, yet only represented 22% of the total number of deals. The average angel and seed deal was $2 million with an $8 million valuation. The average early-stage deal was $7 million with a $36 million valuation, and the average late-stage deal was $13 million with a $163 million valuation. There are a total of 15 U.S. FinTech private unicorns with a valuation of approximately $41 billion. Last year, 6 U.S. FinTech companies became unicorns, including Affirm, Coinbase, Symphony, Clove, AvidXchange, and Robinhood. In Robinhood's case, they're a zero-fee stock and crypto trading app, and recently raised an additional $350 million at a $5.6 billion valuation. On the IPO front, GreenSky recently filed for an IPO. GreenSky arranges home improvement loans and is reportedly looking to raise $1 billion at a $5 billion valuation. Many FinTech unicorns have avoided IPOs due to the pressure of investors and quarterly earnings. Shares of some FinTech IPOs like Lending Club and On Deck have done terribly, falling 70 to 80% since their public debuts. On the positive side, Square, which went public in 2015 at a $6 billion valuation, now has a market cap of approximately $20 billion. In general, FinTech IPOs trade at somewhere between 8 to 16 times enterprise value over revenue. Over the last few years, banks have actively invested in FinTech startups across data analytics, infrastructure, alternative lending, personal finance, management, and more. Goldman's made 26 investments, Citi 22, JP Morgan 10, and Morgan Stanley has made 6 investments. We're beginning to see this change, and banks are foregoing partnering in favor of building it on their own. A good example of this is Goldman's Marcus. Marcus is an alternative lending platform offering no-fee loans with flexible payback and installment terms set by the consumer. This online lender hit $2 billion in originations in November 2017, just a year and 1 month after its launch. I'm sure many of you know this, but an interesting tidbit is the name Marcus comes from the founder of Goldman back in 1869. I'm sure more of you did not know that, but the trends in FinTech The major trends we're seeing in FinTech include AI tech and big data, capital markets tech, ICOs and blockchain, mobile and cloud, consolidation, M&A activity, and reg tech. In M&A activity, FinTechs are becoming more aggressive in expanding their lines of businesses beyond their initial use case and acquiring other FinTech companies. A good example is Credit Karma, a company that provides free credit scores. In December 2017, Credit Karma purchased One Price Taxes, an online preparation and filing service. In January 2018, Credit Karma also partnered with MetaBank to offer online tax refund advances up to $1,000. Users of this no-interest loan receive the advance via an American Express prepaid card. In AI, tech, and big data, although still in its infancy, we're just beginning to see real-life implementation in FinTech. For example, B of A created a chat box called Erica that provides financial guidance to their customers. Similarly, Capital One created an AI-driven SMS chat box named Eno. Blockchain, a good example is Figure. Figure leverages blockchain technology to offer home equity loans in a matter of minutes. They just raised $50 million from DCM and Ribbit. In Reg Tech, banks' investment in Reg Tech still is in their early stages, from identification and background checking software to blockchain and trade monitoring. Banks like Santander, Barclays, and Goldman are some of the earliest to invest in these Reg Tech startups. A good example is Visible Alpha, an investment research and compliance firm. Investors and consumers include Citi, Morgan Stanley, Goldman, B of A, and UBS. These banks co-invested to meet research unbundling requirements of the EU's Markets in Financial Instruments Directive. In ICOs, it's very interesting and very topical. ICOs are clearly on the rise globally. However, the regulatory environment has created significant uncertainty. That being said, traditional venture capital feels threatened and actually have begun to invest in ICOs. On the last trend in capital markets tech, I'm going to turn it over to Richard, and he's going to be speaking about capital raising in FinTech.
Thank you, Ken. So I'm Richard Luftig from Castle Placement, and I'm going to talk about FinTech as it relates to investment banking and capital raising. I think it's pretty funny that investment banks, when they're talking about their clients, like to emphasize how their clients have embraced technology, are disrupting industries, and the investment banks themselves, in my opinion, have not embraced technology very much at all. So most investment banks seem to be stuck in 1952. They try to close transactions at the country club or on the golf course, and the rest of the world is moving at 1,000 miles an hour, making things more efficient, and investment banks have to catch up. So raising capital, as most attendees know, is one of the most difficult things to do in business. And that's just to close a transaction. Getting the best possible execution on your capital raise is extraordinarily challenging. Very hard to track whether an issuer got the best execution possible, but odds are that they didn't. And one of the major reasons is that there is a tremendous inefficiency. So if you think about it, there are millions of private companies around the world, and there are millions of investors around the world. And for decades, through different mechanisms, these companies have tried to find these investors. Now, A typical way of accomplishing that is for, let's say, a teacher to have money in his or her pension fund, and that pension fund investing that money in a private equity firm or a hedge fund, and that private equity fund or the hedge fund investing in a company. Lots of fees, lots of intermediaries, lots of inefficiency. Now, in the last, let's say, 5 years, a number of technologies have emerged and evolved, and the law and the regulatory environment has changed dramatically. And the confluence of all of those factors have changed the way capital can be raised, to a small degree the way capital is being raised, and in our opinion, to a massive degree how capital will be raised over the next 5 to 10 years. So what are some of the things that have happened over the last 5 years? Crowdfunding emerged, and all of a sudden, companies could reach out to regular people, communicate with them, explain to them what their opportunity set was and how they plan to execute their business plan and raise money. The internet has been around for a long time, but over the last 5 years, as we all know, has become an incredible force in everyone's, well, in most people's lives. I won't say everyone because my parents certainly are not in that camp. Social media has started to influence how capital is raised in a significant way. Reg A+ and the Jobs Act in general has dramatically changed the way companies are allowed to communicate with investors. And as Ken mentioned, ICOs and blockchain technology have emerged, and although the regulators are catching up, there clearly has been much controversy about the way capital is raised in an ICO and whether or not those methodologies comply with securities laws and regulations. But as that all evolves, the one thing that is clear is that the way capital is being raised is changing dramatically. So if a capital raise is going to be successful, and again, I can't emphasize this enough, successful doesn't mean we raise the capital. Successful means we raise the capital on the best possible terms, economics, structure, documentation, etc. Investors see hundreds, if not thousands, of transactions each year. It's very difficult to get an investor's attention and to make your transaction as an issuer, which may be the most important thing in your life, important to a prospective investor. Technology and FinTech is and can play a major role in accomplishing that goal. At Castle, we're currently working on 75 live transactions. We have 64,500 institutional investors, and we have 17 investment bankers. That's a lot of deals, a lot of information, a lot of investors, a lot of questions, information requests, NDAs, VDRs. It's incredibly challenging to effectively track all of that information so that each investor can see the deal, get all of the information quickly in a cogent presentation, and effectively communicate the opportunity, the strategy, the management team, so that an investor can make an informed decision. If we circle back to the regulatory framework, the Jobs Act has allowed investment banks using FinTech to portray their transactions to an extremely broad group of prospective investors. That was something that was not permitted prior to the Jobs Act when you were doing a Reg D transaction with an exemption from the public capital raising requirements. Now, we can and we do put our deals right on our website with full information, investor presentations, an overview, a full description of the opportunity, full description of the strategy, bios of the management team, an NDA, a click away, access to the VDR with a password, a click away, all allowing investors to have a much more efficient process in working on transactions. And that makes a big difference because investors, like all of us, are extraordinarily busy and look for a path where everything is very straightforward and simple for them. Transparency is also something that is accomplished with FinTech in investment banking, and dramatic change from the cloak in which investment bankers have lived for centuries. I guess they were not necessarily called investment bankers, but intermediaries have been around for a long, long time, and brokers to this day still try to keep the process as opaque as possible for many reasons. At Castle Placement, we've decided to go in exactly the opposite direction. We've created an app called CP Go, which gives our clients and our investors complete and utter transparency into the process. So 24/7, our clients can see every investor that's working on their deal. They can see all of Castle Placement's notes. They can see all of the investors' notes, any questions, information requests, concerns, when the investor has signed an NDA, visited the VDR. And we've created basically a mini chat room among the client, Castle Placement, and the investor. Unheard of 3 years ago. And as far as I know, unique in the marketplace, but certainly more to come. As investors and clients have access to information, it will be impossible for investment banks to try to go backwards and keep clients and investors in the dark, in my opinion. So to raise capital effectively, you really need to have a robust technology platform. It has to be scalable. If an investment bank wants to work on a lot of deals simultaneously with many investment bankers and many investors and many clients, you need a technology platform that can keep track of all of that information. But the key is data. That seems trite. That phrase is used so often that I'm sure many people are sick of hearing about it. But in investment banking and in FinTech in general, data is king. And we have spent so much of our time, money, and resources on data with respect to prospective clients and with investors. So, for instance, when we're launching a deal, we basically push a button and are able to determine of our 64,500 investors, which investors are appropriate, targeted for that particular transaction. And we have painstakingly looked at each investor and not the firm, not Blackstone or Apollo or Fortress, but each investment professional at that firm. And on a very granular level, we have tried to determine what he or she likes to invest in. So that is industry, geography, size, the stage, part of the capital structure. So now we have that information on the person. Obviously, we have that information on the deal that we're launching. What we've built is a platform that can match the investor to the transaction. And we use artificial intelligence and machine learning to do that accurately. So every time we launch a deal, if you think about it, we're getting extremely valuable new data because Joe Smith, working at private equity firm X, is either interested or not interested in that transaction. And we know the granular data regarding Joe Smith's investment criteria. So now the machine can learn which investors are interested in which deal, what characteristics of that deal are driving the investment decision by the prospective investor. And then we use the machine to help us, when we launch the next transaction, be more targeted. And I think that investors really appreciate that because they don't want to see deals from an investment banker that are not applicable to them. That would get old really quickly, and they get annoyed, and they will really not want to work with that investment bank going forward. So we think that there are hundreds of steps involved in the capital raising process. Even before you start to raise capital, obviously you're meeting a prospective issuer. You're determining whether that issuer will be attractive to investors. Once that's occurred and you've onboarded the transaction, signed an engagement agreement, there's investor presentation, a call, an NDA, BDR, setting up meetings, doing thorough due diligence on the issuer, fulfilling information requests from investors and their investment committee, putting together a term sheet, the legal documents, helping the investor through their final due diligence process and closing. Trying to do that with sticky notes and spreadsheets may work on one deal, may work on 5 deals. Once you get past 5 deals and a few investment bankers, you're in big trouble. And we feel that investment banks that are not investing the time, money, and resources into technology to meet the needs of these increasingly complex transactions are going to suffer. So the last thing I would mention is that FinTech is great. Technology is really exciting. But at the end of the day, still need experienced investment professionals. I think you always will. And that's a super important concept, which may be intuitive, but is lost on many FinTech companies. There are a lot of crowdfunding sites and online brokerage sites, many of which may be legal and regulatory compliant, many of which may not. But we think it's going to be very difficult to raise capital relying on sheer technology. You still need investment bankers to hold the client's hand, to help them prepare information, to communicate that information to investors, to structure transactions, to negotiate, to work on documents, to solve problems, and to close transactions. We have 17 investment bankers, average 25 years, and I can't think of a transaction where that expertise or experience hasn't been super important. So that concludes my remarks, and thank you very much.
Great. Well, thank you, Richard and Ken. We really appreciate it. Now we're going to turn to one particular investor in these transactions, the banks and the bank holding companies. Again, this is Greg Lyons. I'm with NAHAB. We're going to talk about, obviously, what Richard and Ken have focused on are kind of broader offerings and so forth for these institutions. But obviously, the banks have also been, as was pointed out earlier as well, a significant investor in this technology for a variety of reasons, which we'll get into. And what we'd like to talk about over the next half hour is both what banks are doing and why in this space, but also how, a little bit as to how to think about these investments and the different ways you can structure them and different things to think about as you're putting them together. So with that, the agenda, hold on a second here. Again, the agenda is just talking about the trends, then the control issues. I'll turn it over to Neha to focus more on some safety and soundness and some recent regulatory developments. This slide, I'm not going to spend a lot of time on it because, frankly, Richard and Ken spent a fair amount of time on it as well as the different types of investments that the U.S. banks are making. You can see they range across the whole spectrum. And really, we'll get to it in a second, but a lot of the purpose of them is to basically facilitate the customer experience. But you can see it rolls across the entire spectrum of issues. Some banks very, very active, particularly the larger banks, very, very active in this space, but frankly, all of them. Obviously Capital One and any number of banks very active in the FinTech space these days. And so, again, and certainly we've also represented a number of our regional and smaller banks that also are very, very active in this space and looking, again, to enhance their customer experience and figure out additional ways to connect with customers. Neha?
So why are banks investing in FinTech? So as Greg noted, since 2012, the top 10 banks have really, either made majority stakes in a number of FinTech firms or have acquired a number of FinTech firms. There are a few reasons for this. One in particular is customer demand, and this is primarily that customers these days want faster access to all sorts of services, including financial services, through their mobile applications and via the internet. So to meet customer demand, new technologies through FinTech firms has been sort of grown over the past few years. Banks, in turn, have sought to meet this demand either through doing this on their own, as was mentioned earlier, Marcus is one example of this, or by acquiring and integrating FinTech platforms into their own experience. This not only allows to provide customers with access to these services in a faster manner, but also to create faster innovation within the bank itself by leveraging the platform, the FinTech platforms. And in turn, it also provides more access to financial services to these customers. A number of customers, the various regulators have mentioned, have been unbanked in the past few years, and this gives greater access to new channels of customers in a variety of different ways. The other thing to note is this can operate as a defensive measure, and the reason for this is new entrants into the market. Companies like Amazon and Google have been expanding their payment options and their operations more generally. And so by acquiring FinTech firms, banks are strengthening their partnerships, strengthening their own platforms, and providing these services to customers.
Great. So where are we going? I mean, I think as was indicated in on Castle Placement slides, certainly this is a trend that is increasing. 82% of U.S. commercial banks plan to increase FinTech investment over the next 3 years. Again, I think to Neha's good point, it deals with access, it deals with convenience, it deals with a lot of different things. There's a lot of studies now how convenience is kind of penultimate for customers in thinking about their choices for things. 86% of bank senior managers said they intend to boost FinTech funding in the immediate future. And again, from one of our good clients, Silicon Valley Bank, clearly a leader in the field on the West Coast, the basic point is it used to be who's going to win. Is it going to be FinTech or is it going to be the banks? And, about every 10 years, somebody says the banks are the dinosaurs, the bank's going to lose, and somehow they've survived for quite some period of time. And I think the key point is that what's happening a lot, as is typical in this industry, is rather than seeing themselves as competitors, and certainly they compete in certain areas, the banks are trying to align with the FinTech companies where it makes sense. They're trying to invest in them, use them to support their platform, use them to build out their customer base. And that's what we're going to focus on for the rest of this presentation, is really how can banks do that? How can banks, both through investment and through contractual means, align more with these FinTech firms for their improvement, for investment purposes, but also, frankly, for the benefit of their customers. So these are various bank investment arrangements that we're going to talk about a little bit. First slide is types. This very colorful slide on the types of bank FinTech investments. There's basically two types. There's the holding company level, which is where the blue is, where you can do controlled investing, which is basically where you acquire the entire company or at least a significant stake in the company. There's the non-controlled investing, which is, I think, frankly, the most predominant, where the bank takes an equity stake. We're going to talk about the different levels of that in a minute. The bank takes an equity stake but does not take control, and control is many folks, so I see a lot of our bank clients on the phone. Obviously, that has a different meaning in the banking world. It's a much lower level of control required to be subject to banks to control for banking law purposes and might be for GAAP or other purposes. And then there's always merchant banking at the holding company level where you're acquiring the entire company. In fact, some would say this is, in fact, what the merchant banking rules predominantly were created for back in 1999, to support a bank's ability to invest in FinTech and other things. But again, in that case, you really can't have much engagement with the company at all. That becomes purely a speculative investment. We're not going to focus on that today. Clearly, that is a means to do this. But frankly, I think as the tenor of this has shown, a lot more is happening with alignment of banks with FinTech companies. So we're going to focus more on the non-controlled particularly, but also talk a little bit about the controlled. Those are all as the strange circle highlights at the holding company level. And then the other way you could do it, obviously, is at the bank level. The banks themselves, the OCC, the Fed, the FDIC, all have mechanisms for minority equity interests in companies where you don't have control, as well as controlled, where they make it an operating subsidiary or something like that. The difficulty with those, as opposed to the holding company, is those clearly have to be bank permissible investments. Whereas you can do it a little differently at the holding company level. You have a little more flexibility. The other big thing is, for example, the OCC or the bank regulator has to have the right to go in and examine the company if it's at the bank level. They have to have certain controls to make sure they can't do other types of activities beyond the bank permissible activity. And more generally, At the bank level, banks, is again, many folks on this call well know, are not supposed to make speculative investment in stock investments for the most part. They're very limited in their equity investing. So it's generally a much more controlled environment. Certainly can be done, and certainly we've done some, but I think most do it off the holding company when they're thinking about fintech investing. As I say in the bottom, holding company investments generally preferred because they're more likely that fintech remains fintech. The basic point there being, if you do it under the bank level, or frankly, if you control, and we'll get into this more in a moment, at the holding company level, you're basically subjecting the fintech company to banking laws, to the bank holding company or banking laws. Many of them are not so keen to do that. They didn't become a fintech company to be governed, to have examined by the Federal Reserve or the OCC, with all due respect to our fine regulators who might be on the phone. But there's other ways to do this, which allows them to continue to be fintech companies, but not be subject to such strong oversight. So, again, just to kind of highlight on slide 8 the benefits of avoiding control. The Bank Holding Company Act, which is, as folks know, the law that governs bank holding companies, only allows bank holding companies to own or control companies engaged in banking and other activities that are so close related to the business of banking. And so basically, first of all, if you are an absent merchant banking authority, which is a whole separate kettle of fish, if a bank holding company is going to control you, and again, control, let's just kind of, control certainly means if you own 25% or more of the voting stock of a company. That clearly is control for banking law purposes. Again, that's a far lower standard than for GAAP or other purposes, 25% of voting. But as most folks on the call, I'm sure know, you run into control issues in many cases long before you get to 25%, particularly if you also have contractual or other relationships with the company as well. And so it's really, we'll get into this more in a few minutes, but it's really kind of I call it the bundle of sticks of control, and you got to figure out how to, you can take some away from one area, put more in the other. You basically end up negotiating amongst yourself, frankly, as between how much equity you want to own, how much voting equity you want to own versus how many contractual rights you want to have, and try to reach something that allows you to avoid control. The controlled entities, again, if you are subject to control rules, you're going to be subject to AML, that full range of bank AML policies, regulatory exams, as I mentioned, the time the regulators come in, the Volcker rule kind of kicks in, Reg W. Basically, it basically makes the fintech company like any other bank subsidiary or bank holding company subsidiary. And again, that for many institutions, we do a lot of minority investments in fintech companies on behalf of banks, precisely because they don't want to be. They're very happy to be the team with the bank. They're very happy to facilitate the bank's business, have the bank facilitate their funding and other businesses, but they generally don't want to be subject to the banking laws as they go through with it, or at least to a full extent of the banking laws. So the control standards. I touched on this a little bit before. There's basically 3 clear prongs, and then we're going to get into some other standards as well. Owner controlling more than 25% of the voting shares. The way I think of the banking laws is there are clear ways to be in control. Again, if you own 25% or more of the voting shares of a company, you are in control, period, end of story, and you move on to other things. But there's a lot grayer as to when you're not in control, and that's what we're going to focus a lot of our time on. And you really have to look at all the different elements of it. Controlling majority of the company's directors. That typically isn't the case when we do these fintech investments on behalf of the banks. They typically want one director or maybe even just an observer just to know what's going on, but they don't really try to put their directors in place for the most part. The one exception, this is where merchant banking investing, you can, as a merchant banking investor, have majority or practically even all of the directors of a company on there. But again, the reason you're engaging with this company presumably is because you like what they're doing, you like their historical management. So it's kind of counterintuitive to then replace them with your own people if that's really why you're acquiring the company in the first place. And then the other big thing is exercising a controlling influence over the management or policies of the company. This is the one where all the gray comes in, as I was talking about before. That deals with business relationships. It deals with restrictive covenants. It deals with veto rights. It deals with management agreements. Obviously, at a base level, if a bank is a significant investor, what the bank, from its perspective, would love to do is make sure this thing is not going to act in concert with a lot of other companies, that it's going to be promoting the bank's interest, that it's going to be doing a bunch of other things. But the banking laws limit that. The banking laws limit the ability to do that because the basic way the Federal Reserve and others think is if you can do that, if you can limit the ability of the company to engage in other business relationships, if you can and put restrictive covenants on their ability to offer stock, to make loans, to have transactions with others or other things, that basically that's no different. You just contractually created the same kind of rights you would have through significant voting stock. And so they're saying you can't do contractually what you can't do if you own voting stock, and so you try to make that work as well. On the voting stake, now we'll kind of break down each one of these pieces a little bit more. On the voting stake itself, this is how it kind of breaks down. Usually what you end up doing is having a combination of voting stock and non-voting stock in these companies if you're a bank. The reason you do that is the voting stock is the focus of the Bank Holding Company Act. Again, this is all the bank holding company level, but basically the same rules apply at the bank level. But the focus of the Bank Holding Company Act is the voting stock. That's where really the predominant. There's other limits on non-voting as well, or total equity, but the voting stock is where the limits are. So typically what you end up doing as a banking institution is owning a combination of a smaller amount of voting, and then you take non-voting to try to build out your equity base a bit more without running into control issues. So at less than 5% of voting, you actually have a presumption of non-control. The Bank Holding Company Act says if you own less than 5% of the voting stock of a company, you are deemed you're presumed not to be in control of that company. That's a very useful thing to have. If you plan on having significant other business relationships with the company, significant other issues, if you're otherwise going to be very much engaged with the company from a contractual or business relationship, in many cases you might want to think about staying below 5% of the voting securities so you get the benefit of the presumption of non-control, which again can then offset some of the control issues that might otherwise rise with the business relationships and the contractual relationships. To be absolutely clear, I'm not saying that if you get below 5%, you can do whatever the heck you want from a control or a business perspective, from a contractual perspective, but it does give you a lot more flexibility. And so, for example, we also do a lot of work with activists, defending banks against activists in this space, banks themselves. The activists generally start off at a less than 5% stake because then they can be more like activists in other ways. The same principle with the banks entering into these transactions with FinTech companies. At 15% stakes in voting securities, that's an inflection point. That the policy statement, there's a policy statement that's out there, the minority and equity investment, which basically it's 12 CFR 225.144 for those who are geeks like me and just like to recite statutes or regulations, and that deals with this whole concept of how much voting stock can you own. Now, to be clear, once you get above 5% voting stock, the thing has to either be doing something permissible for you to do as a bank holding company, which many FinTech companies do, or you have to plug it into merchant banking. But at 15%, you still may not be deemed in control, even though it's permissible, it's not necessarily in control, as long as you limit your otherwise equity. The basic test, the basic thing that policy statement on minority investments, when you look at it at first, you're going to see that for those who haven't had a chance to look at it before, it focuses on, or by its terms, it focuses on minority investments by non-bank institutions in banks. But if you look, there's a footnote, I think it's like footnote 3 in there, that says the thing equally applies to bank investments in non-bank companies. So anyway, the same policy statement applies. By its terms, that policy statement would allow a 33% equity investment. So the point being, you do 5% voting or 15% voting, you can then hold up to 33% total equity. So the basic point being the basket of that is non-voting. To be clear, it's not 33% non-voting because then you'd be over 33% total equity if you had your voting added on. But you can do 15%, up to 15% total equity, up to 33% non-voting. Having said that, in our experience, the Fed really prefers you to stay below 24% total equity. So basically 15% voting, or whatever the number may be, and less than 25% total equity. The other thing I will mention is it is rumored, it is not known, but it is rumored that the Fed currently is looking to revise its control standards and come up with some clearer standards on this. If that does happen, we'll obviously maybe do an update call on it, but that may be due out this fall, from what I understand. 25% or more is statutory control. I won't get into it, but if you're in control, it's going to be tougher to get rid of it, and it's almost Shakespearean than if you never had it at all, kind of like the love in Shakespeare. The next slide this is just a summary of kind of stuff we've been talking about. It goes from green to red as far as the control thing goes. If you own less than 5% voting, less than 5% total equity, you have a lot of room to maneuver on the business relationships and other things. You kind of move down until when you get to the red, you might as well have whatever business relationships you want because you're in control anyway. And then anywhere in between there, you see it gets gradations. And the more, again, the basic point being, think of it all as like a bundle of control sticks, with voting stock being a big one, equity being another big one, and then the business and other contractual relationships being another big one. And the more you have of these, the less you can have of those, and vice versa. So it allows the banks, we work with a lot of banks to determine what really is important to them, what they're looking to get out. In many cases, honestly, it's not a pure equity return, it's a business relationship, in which case it's okay to have a smaller equity relationship to veer more on the contractual and business relationship side. Speaking of good old business relationships, again, they're both supposed to be, this is the Fed's guidance, qualitatively and quantitatively limited, meaning that the size of the relationship matters, the market terms and basically what the Fed is looking to do. Again, the basic point, I use Fed guidance, but again, the OCC looks at it basically the same way. The basic point is they want to make sure that the FinTech company has the right to walk away if it wants to from a business relationship, because otherwise it seems to be captive of yours. And also, frankly, that you don't constitute so much of the business of the company. Like, let's say you constituted 80% of the business of the company would then say, you could then say to the company, unless you do what I want you to do, I'm going to take all my business away and basically torpedo the company. So they're also very concerned about the size of the business relationship as well. So if you're setting up a relationship with a FinTech company, if you're a bank, think about market terms, thinking about making it non-exclusive, and think about making it terminable without penalty. All those things are factors cited by the Fed as things that will help to avoid a control determination if, in fact, that's what you're trying to get to. There's some passivity commitments and so forth that get involved as well. That you might very well be forced to sign some passivity commitments if you're investing in a FinTech company, too. Restrictive covenants, this is another thing. In addition to business, in addition to how much of the business do you constitute, how much are you doing, the other thing is what are you stopping the company from doing? And the other thing the Fed's concerned about, again, is if you can basically stop this company from doing anything without your approval by contractual means, in the Fed's mind, that's no different than having voting control to veto anything. So their basic point is, again, this is another way where you contractually build control rights that are substantially equivalent to voting rights, and so you really have to be careful about it when you're thinking about things from a control perspective. So if you can limit their ability to hire and fire people, that's a problem. If you can limit their ability to engage in new lines of business or make substantial changes, that's a concern. To raise additional debt or equity capital or merge or consolidate. Any of those things create control issues. The key point here is, in my mind, the key distinction, I think the Fed's mind too, is when you put protections in place, are you doing it to limit the company or are you doing it to protect your investment, your investment itself? But the latter you can do, the former you cannot. So, for example, you can have restrictions on the ability of the Fed to issue, a company to issue like senior equity to yours under the theory that's going to dilute your equity interest. You can do things like basically the same types of rights a non-voting stock might have under Delaware law. You can have those kind of rights because the basic point is you're not doing that to limit the company, you're simply doing that to protect your own investment. And the bank regulators are not opposed to you protecting your own investment from an investment equity perspective. What they are opposed to you doing is putting limits on the ability of the company to engage in activities and other things at a business level going forward. This, again, is another very much a case-by-case analysis as to exactly, I mean, there's some very clear things you can do, like the senior stock and so forth I talked about, but there's a lot of discussion about these types of things, exactly what you can and can't do, what does protect your investment versus what does limit the company, and how to make those determinations. The next question is, okay, so you've done all this, you've worked it all through, you've gotten, you've started to negotiate the contract. What do you do then? Do you either go make your own determination and say, okay, we think we're not in control, and we're just we'll seek forgiveness but not permission from the Federal Reserve if they ever raise an issue, or we'll go to the Federal Reserve staff and seek a determination of non-control. My own view on this is that there are rules, there are laws out there, and lawyers and business folks are as able to read those rules as the Federal Reserve. There are times, don't get me wrong, it makes sense to go to the Federal Reserve if you're in a real gray area and talk about things, but you just have to realize if you do that, you're going to get the most conservative reading of those rules, and you'll be protected. If you get an answer that is, that works for you, you will be protected from be deemed in control. On the other hand, you have to realize you're probably going to end up in a more conservative position than if you made a determination on your own, and that does not mean the determination you made on your own is wrong. So, again, we typically do not go to the Federal Reserve for things. Again, not trying to avoid the statute, just trying to interpret them in what we think is a reasonable way. But again, clearly that is something to be decided. That's a strategic determination to make at the time. So anyway, the point being sticks. Think of sticks, think of control sticks, think of, again, I think when Gramm-Leach-Bliley was adopted back in 1999, merchant banking, the whole theory was banks are going to invest in these things as pure investments, or as almost purely as investments, and unload them and go from there. Since then, the market has evolved. I mean, clearly, I'm sure banks still do a lot of merchant banking. I know Castle Placement has a number of banks on their roster who do this for investment purposes and so forth as well. But also, I think where the market is moving, like any kind of somewhat maturing market, is toward alignment and rationalization as opposed to pure destruction. And I think what you see a lot more, what we've talked, our primary focus with banks now is more really on this issue of how do you align, how do you bring them in, sometimes in a controlling perspective. The control, frankly, analysis is in many ways much easier than the non-control. You take 25 or 30% of the stock, you're in control and you move from there. Usually you take 100 if you're going to get above 25. But where a lot of time is spent on how you can have this stake, how you can have these business relationships, how you can protect your investment to a stake to an extent, and yet not be deemed in control of the company and thus subjecting the company to the Fed limitations, and also, frankly, not making it so the bank holding company is responsible if the company has AML or other issues where the Fed turns around to the bank holding company and says, you did not have the proper controls over this company and we're going to hold you responsible for it. So with that little soliloquy behind me, I'm going to turn it over to Neha to bring this thing home. Go, Neha, go.
Thanks, Greg. So, once you have decided to invest in a FinTech firm.
And how have you decided to invest, Neha?
Regardless of whether you do a minority or controlling investment, there are some safety and soundness concerns that may arise, and a few risks that the regulators themselves have pointed out in various contexts. And so this sort of, we've provided a laundry list of the various types of risks that might arise in these types of partnerships, but a few to call out would include things like cyber risk. In these scenarios where you are partnering with a FinTech firm, or you are leveraging their platform or acquiring a FinTech firm, there may be concerns related to cybersecurity risks and how that firm had appropriately managed their data security. So that's one aspect that the regulators have increasingly been focusing on, and one that has been of increasing focus through these types of acquisitions. The other to consider is third-party and vendor management risk. And we've seen this in a number of different contexts. One, for example, could arise in a situation where the bank itself has the direct customer relationship, but is partnering with the FinTech firm to actually provide the services. There, should the FinTech firm, there should be, if there are any issues with the provision of services, it really is going to be on the bank to make sure that they had appropriate management and oversight responsibilities over the FinTech firm's activities with respect to the customer. The final one to note is compliance risk. And this is more in the context of, as you have FinTech firms leveraging data, using new innovative ways to use that data, there are concerns by the regulators and others related to customer privacy, how that data is being used, how that data might be used during underwriting processes. And so it's a really big gray area at the moment, and one thing to consider, to the extent banks are either doing this themselves or partnering with a FinTech firm. And then moving to some recent regulatory developments, which may be of interest and of note, and may also influence investments in this area. The first is the OCC's Special Purpose National Bank Charter, which was first announced in 2016 by Comptroller Curry. The OCC had issued a proposal saying that they were considering providing a limited purpose charter to FinTech firms in particular to allow them to gain all the benefits of preemption and other benefits that you would get as a national bank. At that point, the New York Department of Financial Services and the Conference of State Bank Supervisors had sued the OCC, saying it was exceeding its bounds of authority, partially because a number of these FinTech firms, particularly those that engage in lending activities, are required to be licensed in each state. As of now, the DFS case was dismissed, and I think the CSBS case is still pending at the moment. There were some remarks by Comptroller Otting recently saying that they would publish their position on the charter in the next 3 months. There is some indication that the OCC may be wavering on the how far-reaching the proposal was originally. But regardless, Comptroller Otting had stated that if the charter were to move forward, or if they were to make any steps towards that any FinTech firm would be subject to the same rules and regulations as other banks. So whether this would be a real opportunity for FinTech firms is unclear. Then the other thing to consider is the Community Reinvestment Act. There's been a lot of discussion by the Treasury Department and the OCC regarding plans to modernize the CRA. And one thing to flag is that the Treasury report indicated, that banks are providing alternative channels or partnering with companies to provide alternative channels for customers. The CRA, and we've dealt with this with many clients of ours, is more traditionally focused on branches and providing products and services through the branch. And banks have struggled as they're starting to provide more digital offerings as to how to accommodate both the CRA's requirements and also accommodate the push and customer demand for more increased digital financial services. So this may be an avenue by which banks may be able to, should the CRA be modernized, banks may be able to increase investments, if a FinTech company potentially has offerings that are provided to low and minority income communities. Perhaps this is one avenue that you may be able to meet CRA requirements. There may be other ways in which CRA modernization may benefit these types of activities, but that's yet to be determined. So with that, I will turn it to Greg.
A couple of things. Just on the AML front, I would just highlight, going back to one of Neha's slides, on the AML front, that's one to really be careful of. Even if you're not in control, if you're a banking institution, AML is just such a hot button in compliance still that I would wait. I would really be careful. I would really thoroughly diligence any FinTech company you're going to invest in and make sure that it hasn't got some AML issues. And that's one, even if you're not in control, you may want to make sure that they have such things. I just don't see how a banking institution does well by itself if it has a significant minority stake in a company that it turns out to have a big significant AML problem. And Neha, do you have any late-breaking development?
Yes, so it sounds like as of, I guess, just recently.
Last night.
Last night, the CSBS case against the OCC's authority for the special purpose charter was dismissed as well. So it looks like the OCC is free and clear if they choose to move forward with this.
Yeah, the OCC, I mean, what the judge basically said last night or yesterday was there may ultimately be no case at all to decide if the OCC does not charter a FinTech. Therefore, even if the CSBS, which is the Conference of State Bank Supervisors, Neha had mentioned, had successfully alleged an injury, in fact, this case is prudentially unripe. So I think it's not decided yet, but basically until the OCC acts, the basic point is we're not going to waste our time. They dismissed their case. So that was last night, a timely thing. I'm reminded here to give the CLE credit. the verification code of 18140. That's 18140, and we finished with 6 seconds to spare, so I hope you're happy about that. Thank you very much. Please send any questions. We're happy to respond to any questions. Thank you very much for your time. Thank you to Castle Placement for joining us in this, and hope you have a great rest of the day.